It's time once again for another episode of Planning Successfully, brought to you by the law firm of Davis, Matthews, and Quigley. Planning Successfully is for general information purposes only, and no information discussed during the show is to be considered either legal advice or legal opinion. Broadcasting live from the Pro Business Channel studios in Atlanta. And now here's your host for today's episode, Matthew Thierry.
Welcome and thank you for joining us for this episode of Planning Successfully. I'm your host, Matt Thierry. I'm joined in studio again today by my colleague, Rhett Peden. Rhett and I have been on several shows together recently, and I'm happy to welcome back Rhett for this episode as well. Rhett and I are both shareholders at the law firm of Davis, Matthews, and Quigley, and we frequently work together on business issues. My practice focuses primarily on business law, such as outside general counsel services for businesses, and business litigation, fiduciary litigation, as well as providing mediation and arbitration services. Rhett, would you like to take a quick moment and introduce your practice as well?
Thanks, Matt. My practice focuses on helping closely held businesses and professional practices and their owners exit their businesses, whether that means they're selling the business or passing it to the next generation, family, or of employees. That's what I focus on, but also my practice encompasses general corporate tax planning and estate planning work as well.
Thanks, Rhett. You can learn more about Rhett, you can learn more about me, and you can learn more about the other lawyers at Davis, Matthews, and Quigley by visiting our website, which is www.dmqlaw.com. Today we're going to talk about a variety of different restrictive agreements and the issues and other types of agreements that surround those. Restrictive agreements and related agreements, sort of the common applications of those agreements, the types of folks that might be subjected to those agreements, and those types of issues are going to be the focus of the conversation. With a lot of areas of the law that we've discussed on this show and a lot that we haven't, a lot of these issues are governed by state law that's different from state to state. We're going to talk a little bit about these in sort of the general context, and in a couple instances, Rhett and I will talk a little bit about some of the state-specific law here in Georgia that applies. For example, when we talk about restrictive covenants in the employment agreement context, there was a general shift in law in May of 2011 here in Georgia, and that dramatically changed how Georgia law applies to covenants that are put into employment agreements. So, Rhett, if you would like, talk to us a little bit about that change.
Well, generally the law became much more favorable for employers after 2011 and really took Georgia in the direction of states that are going towards that. Before that, it was much harder to support a restrictive covenant and have it be enforceable, and that's all changed. Now, you mentioned it was only a few years ago, and it takes a while for these cases to percolate through the system and see how is the new law going to be interpreted differently from the old law. And we haven't fully gotten the contours of that in Georgia yet, but we do think that it's going to make it a lot easier for companies and for the attorneys who draft for companies to get enforceable agreements. And one of the big differences, Matt, between now and before the change in the law, which was actually affected by a constitutional amendment, I think it's important to mention, is the people actually voted on it.
That's right.
Is that now judges have a lot more flexibility to interpret these covenants and to pencil in, or it's called blue pencil, the covenants. That means that the judge can take something that may not be airtight, and they can put in what they think are the reasonable terms to interpret the covenant and to give it some shape. Whereas before, if the covenant was not drafted in such a way that it was easily understandable, the entire covenant would fall apart. Now judges can kind of read between the lines and put their own interpretation into the covenants and make them enforceable, whereas before the whole covenant would fall apart if you were missing some element of it.
Right, and a lot of the analysis that went into the judges looking at these covenants in the past was, is the covenant reasonable? Is there a level of reasonableness within this? And that varied from agreement to agreement. What the employer thought was a reasonable restriction versus what the employee thought was a reasonable restriction led to a lot of litigation. And One of the Georgia Supreme Court justices once wrote in a dissenting opinion that under the old law, 10 Philadelphia lawyers could not draft an employer-employee restrictive covenant agreement that would pass muster under the recent rulings of this court. Now, I'm not exactly sure why Philadelphia lawyers were singled out in this particular instance, but the point is that under the old law, if you weren't very, very narrow in your drafting, you were very, very much at risk of losing your covenants altogether.
Well, I think that's a great point, and that may be one of the reasons, just conjecturing, that we haven't seen the litigation fully develop under the new law, which is under the old law. The fact that a covenant was so easy to challenge, it made it very incentivized for people to challenge those covenants and to take it to court and roll the dice, see if you might win the case and get released from the covenant. The new law has had a chilling effect on that. We've seen it in our own practice when we talk to people and say, is it worthwhile for you to challenge this, or do you want to come to a different accommodation? Because just the way that the new statute is and the new provision in the Constitution, it makes it that much harder for someone to take a chance and challenge that covenant.
And to that point, I think to kind of flesh that out a little bit, under the old law, if the covenant were found unreasonable, the covenant went away. Mm-hmm. The employee was free to do whatever was prohibited by that covenant. Under the new law, with the modification allowance that's provided by the statute, even if the employee is successful in having the court find that the covenant's unreasonable, the court will most likely thereafter modify that agreement and place a restriction on the employee that the court believes is reasonable. Therefore, the employee is not fully released. There's still a restriction. So the incentive for the employee is significantly different than it was under the old law.
That's right. And when I'm advising employers, which is usually where I'll get pulled into this, and we're drafting restrictive covenants, it certainly is an incentive for the employer to try to maybe even overreach a little bit. And an example of that and what we're talking about is that we may have a company that has a lot of different operations across the country. They may sell in a lot of different states. You may be located here in Georgia. Most of your business may be in Georgia, but you may have made a few sales in Florida, Alabama, Alaska. So when you're drafting a covenant, if you're the employer, you may just say, look, you can't compete anywhere in the United States of America. And before 2011, if you had said you can't compete anywhere in the United States of America, a judge would come in and say, well, that's unreasonable. You don't do business across the whole United States. You only do business in Georgia. Since that's an unreasonable element of your covenant, the entire restrictive covenant's going away, and the employee's free to do whatever they want to do to compete. Yeah. Now, a judge will come in and say, well, the entire United States may be unreasonable, but you do a lot of business in Georgia, you do some in Florida, Alabama. We're going to scale it back. Right. So, yeah, the employee is free to compete, but he has to move to Illinois to do it. And so the covenant as a whole still stands. And that's the big difference, and that's where the incentives come in before and after the change in the law.
Yeah, and under the old law, I had a case, for example, where an employee was restricted from competing in what was generally considered the metro Atlanta counties. They listed them out, maybe 15 counties in the metro area. However, the employee only had previously actually worked for the company in about 5 of those counties. And the court struck the restrictive covenant because it was unreasonably broad, because it restricted the employee from competing in areas where the employee did not previously work for the employer. So very much to your point, now under the new law, the court would have the option of striking the counties that the employee didn't previously work in and limiting it only to where the employee actually worked. Therefore, the restriction would still exist, just only limited into what would actually be reasonable. Right. So that's an example of state law specific type of issues. I want to talk in some more generalities about some of these other agreements. I'd like to talk a little bit about non-competes and non-solicitation agreements specifically. Those are often paired with non-disclosure agreements, so I think we'd like to talk about those as well. In addition to the non-disclosure, I'd like to talk a little bit about non-circumvention agreements. Trade secret protection. Trade secret protection, again, kind of skirts the line with the non-disclosure agreement, but there's some additional material with respect to that. And then agreements with respect to assignment of inventions and work product. I think those are all sort of things that you would see typically in a lot of these agreements where people are trying to protect their business from being taken away and moved next door. And I think that's generally the overall purpose of most of these agreements is to protect the ongoing concern of a business so that it can continue to operate without interruption if an employee, a contractor, a joint venture, or an owner, one of these folks decides to leave the business.
Yeah, I think there are really two contexts that we typically see these restrictive covenants come up. One is in the employment context, whether you're the employer or the employee, and ongoing business operations, protecting those, and the litigation that can arise in that context. The second context is when you're buying and selling your company, and we've hit upon that in a couple of our previous episodes, where it's really good to have those agreements locked up ahead of time because it can increase the value of your company and make you a lot more attractive to a buyer if you've protected all your intellectual property, if you've locked up all your key employees. And it's so important to get that done ahead of time, whether you're talking about the employment context or buying and selling a company. I mean, there's a recent example that I know that it's very typical that we've come across, which is even in the employment context, if your employee leaves and you want to tie them up under a covenant, you're going to have to come out of pocket with a lot of money to incentivize them to sign up to those covenants if they haven't before, because otherwise they're going to look and see, well, what is the value you're paying me to not compete with you versus what can I go out there on the market and command for my services? And the employee may well say, you know what, I'm going to go ahead and compete with you. And we have seen situations where the employee's been able to leave the company, not be under a restrictive covenant, and basically clean the clock of their former employer because it was such a valuable employee who left. And had they been tied up under a restrictive covenant, they wouldn't have been able to do that.
And employees are much more likely to sign those covenant agreements earlier in the employment arrangement where they want the job and they want to continue with the employment, as opposed to at the time that they're leaving the job where that relationship's ending regardless of whether or not they enter into those covenants.
That's right. And it's sometimes it's only when someone leaves that an employer has that aha moment and thinks, I should have done this. So again, day one is the best time to do it. Today is the next best time to do it. The worst time is when they actually leave.
Right. So let's talk in just overview first, and then we'll talk about some of the specific applications of these agreements. But let's talk about the different types of agreements. So a non-compete, for example. A non-compete is where you're trying to prevent someone from going out and actually doing the competitive business that competes with the services or products that a company provides for a period of time. Now, there are restrictions. How you look at this is reasonable. Obviously, the duration of the restriction, the territory of the restriction, and then the scope of the restriction. But the general overall theme is we want to make sure that employee, contractor, owner, whomever it is, doesn't decide one day, I'm done with company A, I'm going to company B, and I'm going to do the same thing in direct competition with that company.
Or open up their own new company.
Correct.
That's right. And, when I talk to my clients a lot, what I see is that people aren't necessarily interested all the time in non-competes. What they're actually after is a non-solicit.
Yeah.
And this is very important, especially for professionals and salespeople, is that if you sign up for a non-compete, you're really limiting your ability to earn a living. You could be. And employers don't always want to do that to their employees. They want to be reasonable. What you're actually after in most cases, I've found, is a non-solicit. And a non-solicit, particularly a non-solicitation of clients and prospective clients, is where the employee agrees that they're not going to call upon the customers that their employer has. So if they've developed a route, they can't call on the people on that route. If they've got certain customers they call upon, if they've been made aware of confidential customer list, for example, that their employer has, they're not going to use that to compete against their former employer. What they can do, though, is to go out there, use their industry knowledge and contacts other than the clients to build up a new base of customers and go out there and compete. And typically the employer is going to feel protected as long as their own clients aren't being poached by their former employee. And that's kind of a reasonable accommodation between not having any restrictive covenant in place and having some sort of airtight non-compete that may really be unfair to the employee.
And a lot of times in the previous context, so we were talking about the law prior to 2011, an employer would decide to just completely forego the non-compete agreement because it was so much more difficult to make reasonable than would be to make a a reasonable non-solicitation provision. So you're right. The protection that a lot of employers are really looking for is I don't want this person to leave and then take away my clients with them. If they go and start a competitive business and we're all out there trying to get this new customer that we've never dealt with before and we're running into them, fine. But I don't want to see them knocking on the door of the people that they were working with on my watch.
And another part of the non-solicit is when you see a non-solicit of customers, a lot of times you're also going to see a non-solicitation of employees, which goes along with that. It's not telling someone they can't go out there and compete, but what it is telling them is that you don't want them poaching their coworkers. So if someone wants to leave the company and go somewhere else and work and compete, that's fine, but don't take your whole team with you.
Right.
And so, again, there's some drafting around that can go on to what does it mean to recruit some of your former colleagues and what behavior would fall afoul of the covenant. But the basic idea is leave if you're going to leave, but don't take the whole team with you.
Right. And so that's kind of the general overview of the non-compete and the non-solicitation agreements. Let's talk for a second about non-disclosure agreements. And I think that a lot of times, you get into this issue with, folks are working for the business or provided access to information that the employer wouldn't want to have out in the general public domain. And, whether that be a client list, whether that be pricing information, there are an entire realm of different things that an employer may deem to be confidential, and they want to protect that. So a lot of times when they deal with these issues with an employee, they provide the information to the employee so long as the employee has signed off that they won't disclose that to any third party, won't use it for any purposes other than the business purposes, and to the extent that they have any of that information, they'll return it at the end of their employment.
Where it gets a little tricky was especially with some of our engineering and tech clients. It's always a question between what is general industry knowledge, things that people have picked up, just tools of the trade, versus what are specific issues of IP or technical knowledge that are specific to the company, that are trade secrets or that are protected under the umbrella of confidential information. And that's always a very hard gray area to define that we'll get into with a lot of these employment contracts, or if you have vendor agreements where you're out there hiring an independent contractor who's a tech company or an engineering services firm, and to say, well, if we're doing work for you, for the end client, what part of that work becomes the specific property of the end client, and what part of that is just our general knowledge that we could repurpose and retool and take on to our next engagement. So especially in the IT area and in the engineering and professional services area, it's always a battle, and it's never really clearly demarcated what's going to be protected confidential information and what's not.
Correct. And we talked for a second there when we were talking about confidential information, a little bit about trade secrets. And, as we both know anyway, that trade secrets have a certain amount of protection whether or not a non-disclosure agreement is entered into or not. Trade secrets are more than just general confidential information. They're sort of the secret sauce of the business, so to speak, the formula for Coca-Cola or something along those lines that, without that particular information, this business would be very much devalued. And there you have the certain protections without an NDA, but you also have certain obligations as a company to protect that information, take reasonable steps to protect that information. And, what does that mean? That means, only people that have a need to know kind of basis have access to that information. Everybody in the company doesn't have access to the trade secrets of the company because everybody wouldn't need it. You would protect that information on your computers so that, not everybody could just log into the system and pull up this information. They have certain credentials and access privileges to get to this information. So usually when a trade secret gets exposed or you get into a fight as to whether or not something's a trade secret, and then you start looking into what steps did the employer take to protect this information, to take it beyond just the confidential information level and make it into a trade secret. And
by trade secret, there are statutes on the books that automatically protect that information. Confidential information is something, it can be trade secrets which are statutorily protected, but it's broader than that in concept. So when you talk about confidential information, that's something that an employer and an employee have contractually agreed between them that they're going to respect. But a trade secret, it goes beyond that. That's something that's super special, confidential information that statutes protect for companies as part of their protected property. But what you're saying, Matt, is that if a company doesn't treat something like a trade secret, it could lose its protection as a trade secret. So there are some affirmative obligations that you've got to take in order to get the statutory protection, reasonable steps to protect the information.
And usually, if you're the business owner, you'd want to take those steps anyway so as to protect that information from getting into the hands of people that you wouldn't want to have access to it. I mean, you and I wouldn't want the formula, if we were the owners of Coca-Cola, we wouldn't want that formula out there floating around amongst everyone in the company. That's right. Certainly not something we would be wanting to do that anyway, but in order to maintain that protection, we would have to do it.
Or if I'm an IT company and I've got some special information, but I'm installing it for some third-party applications and it's open for the third party to dissect, that's not something that's protected as a trade secret. That's something that you need to go beyond and independently establish in your contract who's going to have ownership of that property and who can use it and who has a license to use it. You've got to really contractually define that because it's not just protected by the fact that you think it's valuable.
And so that kind of dovetails nicely into the next agreement that we wanted to discuss, and that's sort of the assignment of inventions and work product. And you get that on an employee level, you get that on a relationship with your customer level, and in the IT context, for example. But usually, if you're an employee and you're asked to sign this agreement, the employer is asking you to say, if I develop something while I'm employed here, if I develop some IP, if I develop some code, if I develop any information that would be valuable to the business or to be used in the business, that information doesn't belong to me as an individual, as an employee. It belongs to the company, and that was a part of the services that I was providing to the company. It's to protect that information from walking out the door.
I think that's the basis of the story on the Silicon Valley show on HBO, where the guy goes and takes Pied Piper, and there was the whether he developed it on the former company's Hulu's computer system or not. So I think a lot of people in our listening audience may relate to that. But
sure,
that's the same idea.
And you also get into that same context where you have an independent contractor that's providing services, particularly like we talked about the IT world a lot today. Particularly the IT world, if you have a coder, for example, that's working on a project with you, and you have the relationship with the client, at the end of that project, who owns that code? And that's oftentimes defined by the contract, and if it's not defined by the contract, then you typically have a fight. Usually the end customer wants to own the end product, and whether that's compiled or open source is another issue. But they want to own the end product, and obviously the creative, the person that prepared the coding of it, wants to be able to take that same code and adapt it to other uses. So they don't want to give up the ownership of that. So there's a lot of pushback back and forth between the parties in that context as to who owns what as far as the products go. Mm-hmm. One other agreement that I'd like to talk about for a moment is a non-circumvention agreement, and you see this a lot in the context of third-party independent contractors that a client might work with, or you see this in the context of a joint venture where two companies are going in together to try to accomplish a sole purpose. And the gist of what this agreement is for is to prevent someone from saying, okay, let's work together on this. They get the information from you, and then they all of a sudden say, well, now that I have that information, I no longer really need you. I can just do this without you. I don't need to cut you into the deal. So you get circumvented, essentially. Right. And, there's a lot of situations where this can occur, but usually this is a lot to do in the consulting world. You get a consultant that comes in and says, I can provide you this service, and because of this service, I can help you save this money by doing X, Y, and Z. Well, if you're talking to someone and then all of a sudden they're like, well, yeah, that's great. I hadn't thought about that, but boy, now that you've told me that, I think I can figure this out. If you're that person that's giving up those ideas, oftentimes you want to make sure that someone's not going to take those ideas, cut you out of the deal, and profit from them.
Right. And on the other side, you want to make sure when you're contracting out with a consultant that they're under confidentiality provisions so that they don't go to your competitor and then try to undercut you by selling something that they've adapted from your information that will then benefit your competitors.
And a lot of times you have to keep in mind also, going back to assignment of the inventions and the IP. You know, I have an example that I can kind of talk to you about is I have a friend that was in the IT world, had his own IT business, had started developing a product, and had gotten the product along a good bit of the way, but then some private equity folks approached. And he was looking to bring in the private equity, obviously, to grow that business significantly. And this is in a story I found out after the fact. I wasn't involved in the process. But private equity came in, and they entered into an agreement, and he continued to develop the product, and the product went to market, and then the private equity folks wanted to cash out and sell the company. Well, when they sold the company, he thought he was going to make millions of dollars for having developed this product, but when he was entered into the agreement with the private equity folks, he had assigned to them all of the rights and ownership of the product he was designing. He was essentially converting himself from a co-founder or a founder in this business into an employee of the private equity folks, and he got very, very little in return, and instead became very frustrated when he realized that the private equity folks made millions and millions of dollars on his idea, and he got cut out of the deal. So you know, it's not just the employer that needs to look out for this. It's the venturer that's bringing in private equity. It's the employee that's looking to do something for someone, you know, and a lot of these can be negotiated to make it fair for everyone, as long as everyone's paying attention. When folks aren't paying attention, obviously, you know, someone can
That's when things get slipped into the agreement that, you know, maybe even people aren't trying to take advantage, but they figure, hey, it's the other guy's job to read the agreement and know what they're signing up for.
Right, and representing one party versus another, if you're helping them prepare that agreement, obviously what you're trying to do is get the best deal for your client that you can. What's the client's goal here? Well, in that particular situation, the private equity client's goal was to make as much money as they could when this company sold. Well,
and another thing that I want to mention that kind of here, but it relates to what we were talking about earlier, is the difference between the context in which these issues arise, employment versus buying and selling a business. And,
Sure.
And a lot of times, like you said, this guy went from being an owner to being an employee, and looking back to see, well, what could he have done differently? Well, there's different consideration between the restrictive covenant you enter into when you sell a business versus the agreement that you enter into when you're just an employee. And a lot of times when you sell a business, you do wind up being an employee of the new owner, because the new owner wants continuity. They bought the business because you were doing something good, and they want you to stay on there. Well, there's generally more deference given to the agreements that you enter into when you sell a business than when you just sign up as an employee. And one of the things that I have to kind of walk through a lot of my clients is, look, you've got two separate sources of consideration you're looking at, two different sets of restrictive covenants, and they may not necessarily go together, but the restrictive covenants that you're entering into in connection with the sale of the business can typically be of longer duration and of greater restrictions than what you would enter into as an employee. And once you sign the dotted line that you've signed the stock purchase agreement, the membership interest agreement, or the asset purchase agreement, and however you sell your business, you're really going to be bound by those restrictive covenants. And you know